Hello and welcome. My name is Marc Blatstein, the physician founder of Physician Pre-Sentence Report Service. Today, I'm going to be juggling between this court order, this court appeal final order, and my notes on another computer. I too spent time in federal prison. I'm grateful that I was able to get my medical license back, but I'm now here to help you on your journey. At the end of the video, should you wish to contact me, you'll find my website, pprs.com, and it should be printed on this video also. So I'm going to start here with the end, and that is that the United States District Court granted compassionate release to time served. Now we're discussing compassionate release. Compassionate release, though, ended after COVID did. And so here we had the initial guideline range for this individual was 352 to 425 months. He got a downward departure of, or a downward variance to 292 months. So what I want you to take away from this early on is that prison's temporary. Eventually, you're going to go home. So let's go through this. Just what I've highlighted. It was before Circuit Judge Dana Douglas compassionate release for Joel Francois Jean, and this is a link to the exact website. I suppose I can open this up here. There you go. This is online. And I need to make this smaller. Okay. And so the compassionate release is not a new remedy. In fact, it dates back to at least the Parole Reorganization Act in 1976. At any time upon motion of the Federal Bureau of Prisons, the court may reduce any minimum term of the time the defendant has served. In 1984, Congress enacted the Sentencing Reform Act. Congress established the Federal Parole Board and forbade the federal courts from modifying a term of imprisonment once it had been imposed. But Congress retained an exception for compassionate release motions. Enacting 3582, Congress intended it to act as a safety valve for modification of sentences to assure the availability of specific review and reduction of a term of imprisonment for extraordinary and compelling reasons. So, a heads up, it really matters how well prepared you are for your pre-sentence interview, so that your pre-sentence report reflects who you are and humanizes you to the court and all the stakeholders that are going to be involved in your future decisions for the rest of your stay while you're incarcerated. Through 3582, Congress intended to keep the sentencing power in the judiciary where it belongs, yet permit later review of sentencings in particular compelling situations. Congress explicitly and clearly dedicated that authority to the United States Sentencing Commission, instructing the commission to promulgate general policy statements regarding the sentence modification provisions in sections 3582C, 1A. And these describe what should be considered extraordinary and compelling. In a commentary regarding 1B1.13, the commission outlined 4 categories of circumstances that may be considered extraordinary and compelling: medical conditions of the defendant, the age of the defendant, family circumstances, and other reasons. Notably, it wasn't until 2018 that compassionate release motions could only be brought by the BOP, not by criminal defendants or adults in custody. But in 2018, Congress enacted the First Step Act, which for the first time allowed criminal defendants to move for compassionate release on their own, if denied, directly to their federal court. Therefore, until November 1, 2023, when the Sentencing Commission enacted an applicable policy statement what constituted extraordinarily compelling reasons for motions brought by criminal defendants, was left at the broad discretion of the district courts, limited only by Congress's directive that rehabilitation alone was insufficient. We're going to continue. It was under this framework that this particular district court evaluated and granted Jean's motion for compassionate release. We're going to now turn to the facts of the case. Jean was incarcerated in Texas since 2009. In 2007, he was one of 5 defendants indicted on charges stemming from an ongoing investigation into the use of motels to traffic drugs in the Houston area. On the day that Gene's trials would start, he pleaded guilty to conspiracy to possess with the intent to distribute cocaine and the possession of a firearm. Gene's guidelines, as I related, was 352 to 425 months of imprisonment, and he was ultimately sentenced to 292 months, a downward variance. Years after Gene was sentenced, one or more of Gene's 3 Texas convictions no longer qualified as a controlled substance offense for the purpose of the career offender guideline. That's a big sentence. One or more of Gene's 3 Texas convictions no longer qualified as a controlled substance offense, making him a career offender. In 2023, Gene filed a motion for compassionate release pursuant to 3582 C1A1, arguing that the 3 extraordinary and compelling reasons warranted a compassionate release. First was Gene argued that non-retroactive changes in the law would result in a substantially shorter sentence today. Second, Gene argued that his sentence was unjust because it was no longer than that of his co-defendants and those convicted of more heinous offenses. And finally, was argued that his post-sentencing conduct and rehabilitation weigh in favor of compassionate release. As to the first argument, the district court recognized that Gene would not be considered a career offender. Thus, his guidelines would have been substantially lower. That non-retroactive changes in sentencing law may constitute extraordinary compelling reasons warranting compassionate release when other factors, such as the defendant's rehabilitation, are also present. Accordingly, the district court found that the non-retroactive changes in law may favor compassionate release. Next, the district court identified several distinguishing factors between Gene and his co-defendants before concluding that this disparity did not warrant compassionate release. Finally, and to what I think is the most important, the district court considered Gene's arguments that his post-sentencing conduct and rehabilitation, when combined with other factors, justified compassionate release. We agree that the record evidence of Gene's post-sentencing conduct is remarkable. As soon as Gene began his 292-month terms of imprisonment, he worked with a fever towards self-improvement, education. In his first interview with the probation officer, as the pre-sentence investigation report explains, again, preparing for your pre-sentence interview is critical. Gene stated that he is truly sorry for putting himself, the court, and his family through this, and this will never happen again. He said he's been thinking about how he got into this situation, his thinking patterns, and what he can do differently in the future, including choices regarding his associates. And as this betterment pattern continued, the district court gave significant weight to letters written by the Bureau of Prison officials in support of Gene's release. Of Gene, a BOP case manager wrote, and again, this is why I say it's important to have a routine set up, a plan set up before you go into your pre-sentence interview, before you get into prison. I have over 20 years so the manager wrote, case manager, I have over 20 years experience within the Federal Bureau of Prisons, and I rarely have I come across an inmate that has truly worked on himself from the day of his admittance in the custody of the BOP at bettering himself for an eventual successful return to society. The manager further described Gene as a valuable, trustworthy, and indispensable asset, a true testament of an individual who has educated not only himself, but many of his peers as he prepares for re-entry back into society. Another supervisor with 2 decades of correction described Gene as someone who could become a vital spokesperson and a shining example to thwart recidivism. These remarkable statements guided the district court. Mr. Gene's long, comprehensive record of rehabilitation. Again, it's everything that you can do to help yourself while you're in prison. And the non-reactive changes in the sentencing law together contribute compelling and extraordinary reasons. Finally, the district court weighed the 18 U.S.C. 3553A factors and found that granting Gene's motion was consistent with these factors. Accordingly, the district court granted Gene 3582 C1A1 motion. Gene was subsequently resentenced to time served, followed by 8 years of supervision. There's more here, but I really want you, and I hope you take the time to internalize the points that this court and this judge has found terribly important. And I will, I'm staring at my notes here. So my comment is that this can be a life sentence. This can be a life, there can be life after prison, rather, if you put in the effort. Preparing for the comprehensive pre-sentence interview from the heart. If you can get it into, if you can win the admiration of the probation officer writing the pre-sentence report worksheet for you, then it can get into the pre-sentence report. His pre-sentence investigation report explained that he is truly sorry for putting himself, the court, and his family through this, and this will never happen again. He said he's been thinking about how he got into this situation. The judge got this information from his pre-sentence report, and it only got into his pre-sentence report because he was prepared as he went into the interview. Education and bettering yourself. Both BOP case managers wrote that one with 20 years of experience, they've rarely come across anyone. The other that was truly worked to better himself. The other manager quoted him as a valuable, trustworthy, indispensable asset, a true testament to an individual who has not only educated himself, but many of his peers. It's the effort that you put in once you're inside. Now, there's no guarantees here because there's good auto mechanics and there's bad auto mechanics. You may come across a case manager that is just not going to listen, but this is the flip of a coin, and eventually it will get noticed. And in this particular case, it had to go to the court, but it got noticed. And so I hope that you have found this helpful and my review of this particular judge's order. And I hope you have a good day. I appreciate you taking the time to listen in, and please share with your friends and colleagues. Again, thank you for tuning in.